In this video, we're going to be talking about a new Supreme Court 8-1 order, which may have significant implications for the upcoming election. Now, really quick before we jump into this video, I want to ask you guys for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you support this content, if you want to share this content, please do that. Also, just subscribe to the channel. That does help the channel to grow. And then click the notification icon, turn on all notifications, because that does help ensure that YouTube will actually send you these videos. Now, as I mentioned in the intro, in this video, we're going to be talking about a very important emergency election order that was just issued by the United States Supreme Court. This 8-1 emergency decision by the Supreme Court denied RFK Jr. and his efforts to remove his own name off of the Wisconsin and then also the Michigan election ballots. The two cases we're going to be discussing in this video are called Kennedy versus Wisconsin Election Commissions and then also Kennedy versus Benson. In these cases, RFK Jr. filed lawsuits to have his name removed from the Michigan and Wisconsin state ballots, and he argued that the state's failure to let him withdraw his own name from those ballots would lead to a violation of his First Amendment rights. RFK Jr. argued in his lawsuits that he should be able to remove his own name and that forcing him to have his name remain on those ballots in this critical stage of the election and being in critical states that are swing states would be akin to compelling his speech in violation of the First Amendment and would cause significant confusion, not just for people who potentially wanted to support him, but also now the person he's endorsed, who is Donald Trump. These challenges recently made their way up to the United States Supreme Court, and in an 8-1 order, the Supreme Court denied review to these challenges and ultimately allowed the states of Wisconsin and Michigan to still have RFK Jr.'s name on the ballots despite the fact that he wanted his name removed. Only Justice Gorsuch dissented on the denial of those emergency applications, so Gorsuch was in favor of potentially granting the application and then allowing RFK Jr. to remove his name. So we need to talk about what happened in these lawsuits, how it made to the Supreme Court, what the Supreme Court did, and what the broader implications are for the upcoming election. Now, some background on this. We all know that Kennedy announced his bid for the presidency most recently as an independent back in August 6th of 2024. He then submitted nomination papers and declared his candidacy to states like Wisconsin and their election commission. Less than 3 weeks after that in Wisconsin, on August 23rd, Kennedy announced that he was going to be suspending his campaign, and he attempted to withdraw his name from the ballots in Wisconsin and also Michigan. On August 27th, the Wisconsin Election Commission voted to deny Kennedy and his request to remove his name off of those ballots. The Wisconsin Commission cited state law providing that anyone who files nomination papers and qualifies to appear on the ballot may not decline nomination. The name of that person shall appear upon the ballot except in cases of death. So the claim from states like Wisconsin was that under state law, once you file nomination papers and you are qualified, you cannot remove your name from the ballot, and the only time your name could be removed is if you died prior to the election. Kennedy filed a lawsuit to challenge this decision by the state of Wisconsin. He filed a state court lawsuit, but the state court on review denied that request. Kennedy then went to the Wisconsin State Supreme Court, and he wanted again for the Wisconsin State Supreme Court to side with him and remove his name, but ultimately they upheld the lower court's decision. Kennedy had also attempted to do the same in the state of Michigan by filing a state lawsuit in Michigan against the Michigan Secretary of State, Jocelyn Benson, who also, at that time when he went to her, rejected his request to have his name removed from the ballot. Like I said, Kennedy went to the state court also in Michigan and ultimately also up to the Michigan State Supreme Court, who again ruled against Kennedy and said that Michigan could keep his name on the ballot. In his federal lawsuits, he argued that his constitutional rights had been violated based on the First Amendment. In those lawsuits, he asked for the federal courts to issue an order barring Benson from putting his name on the ballots. Now, on review, a U.S. District Court Judge Denise Page Hood on review denied his request for the order. RFK Jr., in response to the denial, once again then appealed up to the Sixth Circuit Court of Appeals. And recently, at the end of September, the Sixth Circuit Court of Appeals upheld those denials. So at every level so far, RFK Jr. has lost, even at the Sixth Circuit Court of Appeals level. Now, the decision of the Sixth Circuit Court of Appeals found that Kennedy's claims were barred because he had already litigated all of these issues at the state court levels. He had already went to the Michigan and Wisconsin state Supreme Courts, and that this was almost a rerun of his original lawsuits. Now, after losing at the Sixth Circuit 3-judge panel level, he then sought a rehearing en banc, and that is simply asking for a review of the entire Sixth Circuit Court of Appeals, but that petition was denied. But in that denial of that petition for a rehearing, there were some dissenting judges who agreed with Kennedy, who wanted to review this case and ultimately agreed that his name should be removed from the ballots. Now, after that denial of the rehearing, that then led Kennedy for the last time to have one last option, and that was to go to the United States Supreme Court, and he filed petitions for Supreme Court review in both the Wisconsin and Michigan cases. And those, in some ways, have been consolidated, reviewed, and considered by the Supreme Court, and we got an order from the Supreme Court. Kennedy argued in his petitions that his name could easily be removed from the ballot by placing a sticker over it. In contrast, the state of Wisconsin and Michigan argued that that wasn't really possible and would require too much manpower this close to the election. They also argued that over 1 million people had already started to vote, had early voted, and his name was on those ballots. And so there would be no way to kind of undo that. It would cause a lot of confusion based on the people who have already voted and those who have not. Now, Kennedy in his petition stated that this case presents a question of exceptional importance. Does forcing a person onto the ballot compel his speech in violation of the First Amendment? The repercussions of that question are enormous. If a candidate can't stop his name from appearing on the ballot, could battleground states put President Joe Biden back on the ballots? Could states put anyone they wanted on the ballots in violation of the election laws? So Kennedy argued in his petition to the Supreme Court that this case is very important, and in some ways what is happening here is there would be no way for to prevent other states who maybe wanted to cause issues and cause critical debates in swing states from including Joe Biden's name also on the ballot to then take votes away from Kamala. Now, in response to that, Wisconsin and Michigan are both saying that's not really what they're doing, and that simply Kennedy is upset because his litigation at the state court levels did not go his way, and that if he really wanted Supreme Court review, if he wanted an emergency review by the Supreme Court, he should have went to the Supreme Court immediately after he lost at the state court, Supreme Court levels, instead of then filing a lawsuit at the federal court level. And so this was in front of the Supreme Court, and now we have received an order from the Supreme Court. The Supreme Court order states that the application for injunction pending appeal presented to Justice Kavanaugh and by him referred to the court is denied. Justice Gorsuch's dissenting stated that respectively, I dissent for substantially the same reasons given by the judges down below at the Sixth Circuit en banc panel level who wanted to grant review and dissented from that opinion. So that was in the Michigan case. That was the order the Supreme Court issued in that. And when it came to the Wisconsin case, they just simply stated that the application for injunction pending appeal presented to Justice Barrett and by her referred to the court is denied. We did not have any, notice from Justice Gorsuch that he was dissenting, but I would assume it was kind of the same way. You had Justice Gorsuch who potentially wanted to grant applications in these cases, but the other justices were not interested. So in an 8-1 order, the Supreme Court has denied the emergency request to have RFK Jr.'s name removed from the critical swing state ballots that are now going to be voted on. Justice Gorsuch would have been the only one wanting to grant requests for review in this case, maybe grant the emergency application to remove the name. He agreed with some of the dissents from the Sixth Circuit en banc panel, some of those dissents and some of the judges who wanted to grant review to this case. Now, in some of those dissents, those judges stated that I am particularly disappointed by this court's refusal to consider even modest relief, such as placing notices at polling places which state that Kennedy is no longer running for president. This form of relief was deemed appropriate in other states, but apparently not in Michigan. Such relief would not alter the election rules, but rather minimize the risk of voter confusion created by Secretary Benson's actions. Standing idly by in the face of this constitutional violation is a disservice not only to Kennedy, but to all Michigan voters. In an extremely close presidential election, the presence of a third-party candidate on the ballot can be decisive. So those were the words of the dissenting judges at the Sixth Circuit level, and that's what Justice Gorsuch agreed with, but ultimately he was outvoted 8-1. So this is another critical election order coming out of the Supreme Court just days before the election. This is going to impact those critical swing states like Wisconsin and Michigan, because now you're still going to have RFK Jr.'s name on the ballots, and potentially some votes will be taken from Trump, maybe some of the other candidates as well, even though RFK Jr. wanted his name removed, and he is currently supporting and endorsing Donald Trump and wants his supporters to also vote for Trump. So another critical Supreme Court election decision, that's what's going on, and I'm sure we're going to get even more election decisions leading up in just a few days to the election. And so if we get any more information, I will let you guys know. So if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.